In this video, we are going to talk about taxation, specifically on the Ponencias and separate opinions of Justice Lazaro-Javier. This is part of our Bar 2025 review series. So let's proceed. Let's start with the Ponencias of the majority opinions. So in the case of Association of International Shipping Lines versus Secretary of Finance, facts showed that shipping companies challenged RR number 15-2013, which imposed regular corporate income tax on demurrage and detention fees, arguing these were exempt as part of freight income of international carriers. So the issue is, are demurrage and detention fees earned by international shipping carriers exempt from income tax as freight income? Ruling? No. The court upheld RR 15-2013. Demurrage, detention are not freight, but compensation for delay in returning containers or using them beyond the agreed period. Hence, they are taxable income. So the doctrine here shows that, as a rule, freight means payment for actual carriage of goods, and demurrage, detention are not freight. Thereby, they are penalties, charges, and thus taxable. The explanation for this is that the exemption for international carriers under the NIRC applies strictly and cannot be extended by analogy. Thereby, tax exemptions must be clear and express, otherwise income is taxable. Let's go to another case. In the case of BIR versus E-Bank Tower Condominium, facts showed that a condominium corporation collected association dues and membership fees from unit owners. The CTA ruled they were not subject to VAT. So the issue here is, are association dues, membership fees, and assessments collected by condominium corporations subject to VAT? Ruling? Yes. Such dues are subject to VAT as consideration for services provided by the condominium corporation to its members. This includes maintenance, utilities, and management of common areas. The doctrine applied here is the rule that VAT is imposed on the sale or exchange of services in the Philippines. Thereby, condominium corporations, since they render services to their members, the dues are consideration for such services. Thus, prior BIR rulings exempting them were invalid because administrative issuances cannot override the law. Another case is on Taihi All-Tech Construction versus CIR. In this case, the taxpayer sought a VAT refund under Section 112 of the NIRC. The BIR denied it, citing RMC 42-2003, which imposed extra documentary requirements. So the issue is, can the BIR, through RMCs and RRs, impose requirements beyond those found in the NIRC for VAT refund claims? Court ruling? No. Administrative issuances cannot expand or restrict what the law provides. VAT refund claims are governed strictly by the statute, not by additional BIR-created conditions. So the doctrine applied here is the rule that VAT refunds require proof of A. Zero-rated sales, B. VAT input payment, C. Proper substantiation, and D. Compliance with prescriptive period. The reason behind is that revenue regulations circulars cannot amend the law. Only Congress may legislate requirements. Hence, BIR issuances that burden taxpayers beyond the NIRC are void. Let's go to another case, CIR versus Toledo Power Company. In this case, Toledo Power claimed a VAT refund, solutio indebiti, for alleged erroneous VAT payments. It relied on informal assurances from BIR officers. The CTA granted the refund. So the issue was, are informal settlements with BIR officers binding on the government? And what governs VAT refund claims? The court ruling? No. Only the CIR or authorized officials may bind the government. Refund claims must strictly comply with statutory periods and evidentiary rules. CTA's refund grant was then reversed. The doctrine applied here are, first, only CIR or authorized officials can compromise tax liabilities. And second, tax refunds must be proven clearly and filed within the 2-year prescriptive period. The explanation is that taxes are the lifeblood of the government. Refunds are construed strictly against taxpayers. Informal or unauthorized settlements don't bind the state. Thus, taxpayers must rely solely on statutory remedies. Now, let us go to separate opinions, specifically dissent. Let us start with a case on offshore POGO licenses. So in this case, the Philippine Offshore Gaming Operators or POGOs, licensed by PAGCOR, operated from the Philippines but serviced only foreign clients. The BIR assessed them for income tax, arguing their income was sourced from the Philippines. The POGOs claimed exemption, reasoning that since their services were for foreign clients abroad, their income was foreign sourced. So the majority ruling of the Supreme Court held that offshore-based POGOs were not subject to Philippine income tax for income earned exclusively from foreign clients. Since the source of income is the situs of the service recipients abroad, such income was not considered Philippine sourced. However, Justice Lazaro-Javier has a dissenting opinion. She disagreed, arguing that POGOs derive income from the Philippines because the situs of the activity, which include gaming operations, facilities, manpower, is in the Philippines. She cited the twin characterization test and sliding scale test to conclude that income arises at least partly from the Philippine sources. Thus, they should be taxed as resident foreign corporations under the NIRC. Another case where there is a dissenting opinion was on the excise tax exemption on petroleum products. In this case, a petroleum supplier sold fuel to tax-exempt international carriers. The supplier paid excise taxes, then later claimed a refund, arguing that since the buyer was tax-exempt, the transaction should have been exempt from excise taxes. Majority ruling of the Supreme Court showed or said that the majority allowed the refund, treating the suppliers as stepping into the shoes of the exempt international carriers. Since the end users were tax exempt, the excise tax should not have been collected at all. However, Justice Lazaro-Javier dissents, and she stressed that tax exemptions must be strictly construed against the taxpayer. The law did not explicitly exempt the supplier from excise taxes. Thus, it could not claim a refund indirectly through the exemption of its buyers. She emphasized that only clear statutory language can justify tax exemptions. Let us go to a case whereby Justice Lazaro concurred, and this was on the appointment on book registration. So in this case, the BIR issued Revenue Regulation 4-2014 requiring self-employed professionals to register their appointment books with the BIR. Here, a challenge was filed questioning whether this requirement had a legal basis. So majority of the Supreme Court justices ruled by striking down the regulation as unconstitutional and beyond the BIR's statutory authority. It held that requiring appointment book registration violated the right to privacy and was not supported by any provision of the NIRC. Justice Javier's concurring opinion also states, agreeing that RR 4-2014 was invalid, and further added that it effectively required disclosure not just of the appointment book, but of its contents. This went beyond Section 5 of the NIRC BIR's power to obtain information and intruded on professional privacy. She characterized it as ultra vires and unconstitutional for overreaching statutory authority. All right. If you found this video useful, substantial, please like, share, and subscribe, and watch for more videos like this. Daghang salamat.